Get ready for the dictation. Start. Petitioner at the relevant point of time was the senior clerk in the office of District Non-Formal Education Officer, Varanasi. The Joint Director of Education, via the first impugned order dated 3/12/1997, has held that petitioner is substantively appointed senior clerk and was temporarily promoted to the post of senior assistant in a local arrangement, and since disciplinary action is proposed to be initiated against him, as such he is being sent back to his substantive post of senior clerk. The second order under challenge is an order of suspension passed against the petitioner on 22/1/1998 by the Joint Director of Education, which records that since disciplinary action on serious charges is contemplated, therefore he is being placed under suspension. It is after a gap of 13 long years that a charge sheet has been issued to petitioner on 12/10/2011, leveling 5 charges against the petitioner, which is the third order under challenge. The charge sheet is assailed on the ground that neither any material in support of the charges exists nor any disciplinary inquiry would be permissible in absence of such material. It is also urged that the delay of 13 years in initiation of disciplinary action is not explained and in the facts and circumstances is wholly arbitrary. It is also contended that for a period of 13 years during which petitioner was placed under suspension, even subsistence allowance was not paid to him, which renders the entire disciplinary action unsustainable. Sri Kartikesaran, learned counsel appearing for the petitioner, places reliance upon a judgment of the Supreme Court in P.V. Mahadevan versus M.D. T.N. Housing Board 2005-6 SCC 636, as also a division bench judgment of this court in special appeal defective number 202 of 2021, Neelu Dwivedi versus Artificial Limbs Manufacturing Corporation of India and others, to submit that unexplained delay in issuance of charge sheet would vitiate the charge sheet and it is liable to be quashed. Sri Sailendra Singh, learned standing counsel, on the other hand, contends that charges against the petitioner are extremely serious, and for ascertaining the cause of delay in issuance of charge sheet, an inquiry by a 3-member inquiry committee has been constituted. It is also contended that delay was occasioned in issuing the charge sheet on account of inter-district communication between different officers, since the charges related to a period when petitioner was posted at Bahraich, whereas he was in fact serving at Varanasi when disciplinary action was initiated. Documents from different offices had to be collected, which contributed to the delay. Reliance is placed upon a judgment of the Supreme Court in UP Cooperative Federation Limited and others versus LP Rai 2007 7 SCC 81, as also the judgment of this court in Dinesh Kumar Bhardwaj versus State Bank of India through Regional Manager and others, writ petition number 39036 of 2012, to defend the impugned action. A prayer is also made to allow the respondents to proceed with the inquiry in view of the seriousness of charges levelled. In reply, Sri Kartikesaran, learned counsel for the petitioner, states that no material in support of the charges are shown to exist on record, and therefore the allegation made against the petitioner in the charge sheet are unsustainable for the mere reason that no material in support of such charges exists on record. It is pointed out that even the subsistence allowance has been paid to petitioner only in the year 2016 after 18 years at the rate of salary admissible as per 4th Pay Commission report, notwithstanding the fact that 5th Pay Commission report got enforced on 1/1/1996. With reference to the affidavits filed by the officers before this court, it is urged that respondents admit that original records are not in existence and therefore holding of disciplinary inquiry would otherwise be an abusive of the authority vested in the employer. It is contended that petitioner has been sufficiently punished for no fault of his, and therefore the disciplinary inquiry initiated against him be set aside, particularly as he has otherwise attained the age of superannuation, and the petitioner be allowed service and retirement benefits as per his entitlement in law. Stop.